We also have Ibu Fitri here, but for some reason, we are really sorry that Ibu Fitri will not be able to participate as we wanted. Sorry for that, Ibu Fitri. I know that you are ill, but we wish you a speedy recovery. But to accompany Ibu Fitri, we also have Ibu Tiana Sigi Pertiwi. Now, I would like to invite our second speaker, but allow me to introduce our second speaker first. Mbak Tiana, full name is Tiana Sigi Pertiwi. You are a lawyer. If I may say a little bit more about you, is a knowledge lawyer at Anggraeni and Partners, right? That's the term that we use, focusing on the ocean, maritime, climate, and trade practice group. So you hold a Bachelor of Laws from the University of Indonesia and LLM from Maritime Law from the University of Southampton. So Ibu Tiana, now the floor is yours.
Thank you, Dr. Andy, for the kind introduction. Good afternoon, ladies and gentlemen, or good morning from wherever you are. As mentioned earlier today, Ibu Setyawati Fitrianggraeni, our managing partner at Anggraeni and Partners, and our second speaker today is still recovering her health from temporary inflammation of her vocal cords. She is present here today among the panelists. Hello, Ibu Fitri. But to ensure smooth delivery of the second session, I will be assisting her by helping to present the following materials on her behalf. We would also like to say that our team at Anggraeni and Partners Law Firm, in support of Ibu Fitri, will also be pleased to discuss with you further on this topic in writing or arrange a separate appointment at a later date as well, if you prefer. We will share our contact email details later at the end of the session for your use. As today we are pleased to speak to you on a subject that sits at a very specific and, as I would argue, increasingly important at this time. Following Dr. Osdale's insightful session, we will be focusing on another aspect, which is the carriage of passengers aspect. Before we further proceed, allow us to firstly clarify the scope of Ibu Fitri's presentation today. This discussion is strictly limited to the issue of personal injury and death of cruise ship passengers in a war risk area. So we are not here to address any subjects or topics related to the political aspects of war or acts of terror. Our lens today is entirely a legal one, although hypothetical, since to our knowledge there is no direct case precedent specifically on this topic yet. So we will examine the current international frameworks governing the limitation of liability for maritime claims and compensation for possible deaths or injury during carriage of passengers when things could possibly go terribly wrong in some of the world's most dangerous waters prone to war risks. With this important framing established, let us begin. Slide. So first of all, we would like to open this session with some practical questions. You may see at this slide, these are real captions of news headlines from the past few months. Some passengers of some number of cruise ships, including MC Arabia here, were stranded in Dubai amid the Middle East conflict, as you may know. Recently, it was also reported that at least 6 passenger cruise ships were reportedly stuck in the Persian Gulf. News outlets such as the Straits Times here reported that the Middle East war trapped over 15,000 cruise passengers in the Gulf. Now, we would like to ask you these questions. What will you do if you were a passenger of one of these cruises? Or alternatively, what will you do if you were a ship owner or operator of that same vessel? These are questions that your clients may ask, the courts will have to answer, and then the international conventions we will discuss today were designed with varying degrees of success to resolve. This raises immediate concerns such as what happens if passengers are injured or if there is a loss of life in that war risk area, who will be liable, and more importantly, how much compensation is actually available. This tension between the passenger who has suffered harm and the operator who seeks to limit their exposure is what drives the entire legal architecture that we are about to examine. Next slide, please. Today's discussion is structured across 5 sections. We started already with the opening scenario just now. Then we will move to the section 2, which is the LMAA, covering both the 1976 convention and its protocol. And section 3 will address the Athens Convention and its 2002 protocol, which governs passenger carriage specifically. Section 4, we will examine a case example. Section 5, a comparative analysis of the regime differences between the LMC and Athens Convention. And we will conclude with some brief key insights for your reference. Let us proceed to the next slide. The Convention on Limitation of Liability for Maritime Claims, or LMC, is a foundational global instrument governing the right of ship owners to cap their liability for maritime claims. So understanding this, who can invoke this right, what claims it covers, and how limitation fund works is quite essential before we can compare it to the Athens Convention. So let's start with the first article of the LMC, the right of limitation and who holds it. The LMC provides that the ship owners and sellers may limit their liability in accordance with the rules of these conventions for the claims set out in Article 2, which we will examine later further. The term ship owner here is defined broadly. So it shall mean the owner, charterer, manager, operator of a seagoing ship. And this is quite an important point of scope since charterers and managers are not excluded. Salvage shall mean any person rendering services in direct connection with salvage operations. And crucially, if any claims set out in the Article 2 are made against any person for whose act, neglect, or default the ship owner or salvor is responsible, such person shall be entitled to avail himself of the limitation of liability provided in this convention. In other words, the protection extends downward through the chain of responsibility. The convention also makes clear that the liability of ship owner shall include liability in an action brought against the vessel herself, and for all purposes, an insurer of liability for claims subject to limitation in accordance with the rules of the convention shall be entitled to the benefits. One final note on the first article, which we think is quite worth to emphasize, is that the act of invoking limitation of liability shall not constitute an admission of liability. Next slide, please. Now, how does the limitation mechanism actually work in practice? Under Article 11, any person alleged to be liable may constitute a fund with the court in sum of such of amounts set out in Article 6 and 7, together with interest from the date of the occurrence giving rise to the liability until the date of the constitution of the fund. Any fund thus constituted shall be available only for the payment of claims in respect of which limitation of liability can be inferred. The fund may be constituted either by depositing sum or by producing a guarantee acceptable under the legislation of the relevant state. Importantly, a fund constituted by one of the persons mentioned in Article 9 or his insurer shall be deemed constituted by all persons mentioned in the corresponding paragraphs. So the establishment of a single fund has a collective protective effect for the group. This mechanism, the limitation fund, is the engine of the LMC system. It is both the ceiling and the remedy. But what claims are actually subject to that ceiling? Next slide, please. There seems to be a technical error, so let's just wait for a bit.
It's on now.
Slide 7, please. All right, so the following Article 2 sets out the scope. The following claims, whatever the basis of liability may be, shall be subject to limitation of liability. This includes, among others included, as we underscore here, is claims in respect of loss of life or personal injury, occurring on board or indirect connection of the operation of the ship. It does not seem to be showing in my... All right. All right. So which is the main subject of our discussion? As shown here, the claims set out in paragraph 1 of this article shall be subject to limitation of liability even if brought by way of recourse for indemnity under a contract or otherwise. And we come to a specific limit for passenger claims, which is the provision mostly directly relevant to our topic today. Under the LMC 1976, in respect of claims arising on any distinct occasion for the loss of life or personal injury to passengers of the ship, limit of liability of the ship owner thereof shall be an amount of 46,666 units of account, multiplied by the number of passengers which the ship is authorized to carry according to the certificate, but not exceeding 25 million units of account. So for the purpose of the article, claims for loss of life or personal injury to passengers of a ship shall mean any such claims brought by or on behalf of the person carried in that ship under a contract of passenger carriage or who with the consent of the carrier is accompanying a vehicle or live animals, which is covered by the contract of carriage of goods. You will also note on the left side of the screen, the general limits of under Article 6 applies to all other claims calculated on a per tonnage basis. Meanwhile, the Article 7 is a lex specialis for passengers carved out from that general system. Next slide, please. Yes, so you may note two important changes from the 1976 original made by the protocol. First of all, the per passenger figure has been raised substantially from 46,666 to 175,000 units of account. Second, and critically, the 25 million units of account aggregate cap has been removed. So there is no longer a ceiling on the total fund of the passenger claims. It scales with the number of passengers carried. This shift reflects the international community's recognition that the original 1976 limits were wholly inadequate for modern large-scale passenger vessels. Next slide, please. So as we can see here, the slide brings the number to life in a more concrete way. So let us walk you through the table. First of all, we are looking at a comparison of 4 example vessels of very different sizes from the allure of the sea as largest with at 225,282 GT with 6,000 licensed passengers. And then the Queen Mary, the Orion, and down to the smallest in this table, which is the SV Sea Spray. She is at 295 tons with 52 passengers. So we will be tracking the applicable limitation quantum across 4 regimes. Under the LMC 1957-1979, the allure of the seas would yield a limit of approximately 46.5 million SDRs for a single incident. Under the LMC 1976 at 46,666 SDR per passenger, the theoretical figure would be nearly 294 million SDRs, but then the cap kicks in. It is capped at less than 1/10 of that, which is 25 million SDRs. And under the LMC 1996, with the cap removed and the rate rise to 175,000 SDRs per passenger, the figure for allure of the seas rises to over 1.1 billion SDRs, no cap, and then the figure is unchanged by the 2015 tacit acceptance procedure, which left the passenger limits untouched. So the data here illustrates starkly why the 1996 protocol mattered so profoundly. Next, please. Now we will turn to the Athens Convention 1974 and its 2002 protocol. So if earlier the LMC is the ship owner's tool, then the Athens Convention is the passenger's instrument. So where the LMC asks how much can the ship owner cap, then the Athens Convention would ask what is the passenger guaranteed. By the time of the adoption of the Athens Convention, there are 25 states became party to it, and it rests on four key pillars, as seen here. First is the international carriage. The convention applies where the ship is flying the flag of or registered in a state party to the convention, or the contract carriage has been made in the state party, or the place of departure or destination according to the contract of carriage is in a state party to this convention. Second, fault-based liability. The carrier shall be liable for the damage suffered as a result of the death or personal injury to a passenger due to the fault or neglect of the carrier or of his servants or agents acting within the scope of their employment. The burden of proof shall be with the claimant. Third, limitation of liability. The liability of the carrier for the death or personal injury to a passenger shall in no case exceed 700,000 francs per carriage. Fourth, the time bar. The limitation period is 2 years from the date of disembarkation of the passenger, but in case of death occurring during carriage, it is from the date when the passenger should have disembarked. If it is in the case of personal injury occurring during carriage and resulting in the death of passenger, after disembarkation, it is from the date of death, but shall not exceed 3 years from the date of the disembarkation. And next, the 2002 protocol modernized the Athens Convention. Today, there are 34 states party to it, and it introduced 5 key changes. First, the strict liability for shipping incidents. The carrier shall be liable to the extent that such loss in respect of that passenger of each distinct occasion does not exceed 250,000 units of account, unless the carrier proves that the incident occurred not through fault or neglect of the carrier, or that it was act of war. The second feature is the precise definition of shipping incident, meaning shipwreck, capsizing, collision, or stranding of the ship, explosion, or fire in the ship, or defect in the ship. And defect of the ship means any malfunction, failure, or non-compliance with the applicable safety regulations. Third, the higher limitation, the liability of the carrier for death or personal injury to passengers shall in no case exceed 400,000 units of account per passenger on each distinct occasion due to the fault or neglect of the carrier or his servants or agents acting within the scope of their employment. Fourth, direct action against the insurer. Any claim for compensation covered by insurance or any financial security pursuant to this article may be brought directly against the insurer or any other person providing financial security. Fifth, compulsory insurance. Carriers are now required to hold a certificate of insurance or any other financial security in respect to the liability of death and personal injury of passengers. Next slide, please. Now we turn from the legal framework to real life application. Although this is not a direct case example of how the Athens Convention or LLMC applies to passenger injury or death in war or terrorism context, but the Costa Concordia disaster we would examine here is arguably the most important mass passenger casualty event in the modern maritime history from a liability standpoint, and it continues to shape the discussion of limitation frameworks to this day. So as you may know, the Costa Concordia disaster occurred back in 2012 when the Italian cruise ship ran aground and capsized off the coast of Tuscany, Italy. The incident was attributed to the captain's deviation from the planned route. It resulted in deaths of 32 people, evacuation of over 4,000 passengers and crew, and the captain was charged with manslaughter, sentenced to 16 years in prison for sailing off course and abandoning the ship prematurely in violation of his duty to oversee orderly evacuation, and ensure passenger safety. This case is a leading example of mass passenger casualty, is illustrating the operation and the limits of international liability and compensation frameworks. The carrier was largely subject to the Athens Convention, which presumes fault in cases of shipwreck, limiting liability for passenger death or injury to a specific amount, roughly 46,666 SDR at the time. In the context of LMC, it is a system limiting liability for the loss of life or personal injury, unless it is proven that the loss resulted from the ship owner's personal act or omission committed with the intent or recklessness. The incident prompted expanded discussion on the establishment and sufficiency of the limitation funds at that time. The actions of the captain, deemed as gross negligence, were central to challenging these liability caps. And following the case, the 2002 protocol to the Athens Convention raised these liability limits and introduced mandatory insurance, significantly increasing protection for future passengers, as we briefly touched in slides prior. Now we bring together two frameworks we have examined and compare them directly. Next slide, please. So let me briefly walk you through the key figures side by side, so the relationship between these frameworks is more clearer on one screen. Under the LMC 1976, 46,666 units of account multiplied by the number of passengers which the ship is authorized to carry according to their certificate, but not exceeding 25 million units of account. Under the LMC 1996 protocol, it is 175,000 units of account multiplied by the number of passengers which the ship is authorized to carry according to the ship's certificate, with no aggregate cap. Under the Athens Convention 1974, the liability of the carrier for the death or personal injury to a passenger shall, in no case, exceed 700,000 francs per carriage. And under the Athens 2002 protocol, the loss suffered as a result of a death or personal injury to a passenger caused by a shipping incident, the carrier shall be limited to the extent that such loss in respect of that passenger on each distinct occasion does not exceed 250,000 units of account, unless the carrier proves that the incident occurred without fault or neglect or was an act of war. So these figures could tell you the story of a gradual but decisive evolution from low capped limits towards high uncapped passenger protective regimes. Now, our discussion today highlights three key differences. First, the LMC is the ship owner's global limitation regime. The primary focus of protection is preventing the financial ruin of the ship owner by limiting the ceiling of liabilities for certain claims. Second, the Athens Convention is the passenger's protection regime. The primary focus is for passengers by providing direct compensation for death or personal injury due to shipping incidents. It is the instruments that basically answer the question, what am I entitled to if I am harmed during this carriage? And third, connecting the two, compulsory insurance and global limitation fund question. The Athens Convention requires ship owners to provide compulsory insurance by enabling direct individual action by passengers. The LMC, by contrast, requires a legal action by the ship owner to constitute a fund and stay on proceedings. The Athens Convention is, in this sense, more passenger-friendly procedurally. The LMC mechanism, while comprehensive in scope, requires the ship owner to take active steps before claimants can be paid from the fund. Let me close with some very brief practical takeaways and insights addressed separately to the groups which we had in our opening question, which is the passengers and ship owners. So for passengers, they should assure before booking or embarking in a cruise ship if their cruise operators can demonstrate valid liability insurance and, where relevant, a blue card covering passenger injury or death under the Athens Convention, especially for voyages into war risk areas or terrorism-prone zones where standard liability policies often exclude such perils unless specifically written back. Tickets are not evidence of insurance, and only the actual insurance contract determines coverage. If the operator of such cruise lack proper cover, the passenger may need to pursue claims based on the contract of carriage and seek compensation in the most favorable jurisdiction permitted by the contract and other applicable conventions. And of course, for ship owners and operators, some of our key insights are you need to anticipate war and terror risk when heading to high risk areas. Acquire appropriate war risk extensions or separate war risk blue card cover for passenger liability, and critically regulatory authorities and port states may also deny access if the ship owner cannot provide evidence of insurance or financial security covering anticipated liabilities. And then overarching both groups, two major principles that we would like to ask you to take away from today's presentation is that, first of all, the existing of compulsory insurance and limitation funds is central to ensuring compensation for passengers, and war or terror is not a blanket defense for liability for passenger injury or death. That means mandatory convention protections shall prevail over contractual exclusions, if applicable, unless the carrier proves intent or recklessness. And as such, that concludes our presentation today on the limitation of liability for maritime claims and compensation for carriage of passengers in war risk areas, which we focused earlier on passenger personal injury and death. This is presented on behalf of Ibu Fitri, our managing partner, Anggraeni and Partners. We hope that this has provided a brief intro and perhaps hopefully a useful map for you on the two primary international frameworks, the LMC and the Athens Convention, on how they interact, how they have evolved, and what it means in practice for both passengers and operators internationally navigating war risk waters. And also to close our second session today, 15 April 2026. As a matter of fact, by the early hours today, 114 years ago, was the exact time when the infamous Titanic sunk. So we would like to emphasize that the safety of passengers should be treated as a priority and paramount. We are happy to arrange a private discussion with you separately at your convenience, either in writing via email or in form of an introductory call or meeting in either our head office located in Jakarta, Indonesia, or in Malmö, Sweden. Please do not hesitate to contact us, discuss directly with Ibu Fitri, or ask the team of lawyers and researchers at the Ocean Maritime Law Sector